letting me know where they are joining us from. So if you hadn't already, please say hello. If you have any questions, please post them into that question pane. We'll be sending a full report with all your questions over to Jason and Matthew a little later today, so please ask away. There are handouts available for this course. I just posted the link for a PDF version of the PowerPoint. There's also 2 other documents. Those are available in the GoToWebinar control panel under the PDF handouts section. This is a 1-hour course eligible for 1 CPE. In order to get that credit, you need to do 2 things: attend this full session and answer the polling questions. Those polls are going to be launched periodically. They're going to pop up on your screen. Just select the radio button that best fits your answer, submit, and you are good to go. If you have any issues with those polling questions, don't worry. We can still get you CPE later with any, if you have any technical issues, just let us know. We'll be reaching out to help anybody if you have any issues with those polls. We'll also be recording the session. We'll send you that link a little bit later today. So let me check in with our audience here. Hello, audience. Thank you so much for joining us here. We have California. We have Francis in Texas, Mark in New Jersey, Rob in Texas, David, Montana, Natalie in Iowa here. I got Puerto Rico, New York, South Dakota. All right, filling in here. Looks like things are working well, and that is my cue to step aside. So Jason, Matthew, thank you so much for being here today. The audience is ready and the floor is yours.
Nathan, thank you so much. We appreciate the opportunity, as always, to join this fine audience, and we look forward to spending the, hopefully for most of you, kind of remaining work hours of your day with us today, talking about an issue that's near and dear to many of us: IRS collections and representations in the wake of COVID-19. As many of you know, Matthew and I have been speaking quite a bit and providing presentations dealing with coronavirus relief, the various loan programs, including the PPP loan program, and other tax aspects over the course of the last few weeks. And if you've tuned into those, you've probably heard us say that this has been like drinking from a fire hydrant and trying to keep up with the continuous legislative and administrative changes. And it has certainly continued to be that. One of the areas that has really kind of jumped out to us, as we've kind of stayed at the forefront of this, has been the collection opportunities and avenues that are made available, in part as a result of some of the legislation and administrative policies that have been adopted, but also in part because of some of the unique economic circumstances that we're all facing in terms of the challenges that frankly open up, for better or worse, open up some collection alternatives that were not there in the absence of that. So this is a picture of me. For those who are wondering who's talking, this is a much better picture of Matt. And I want to give a little bit of introduction because Matt has been at the forefront of the coronavirus relief effort. He has been helping clients left and right navigate these complexities and work through in terms of finding economic relief, and he's got particular expertise when it comes to today's topic. Matt, I'm jealous of some of his perspective. He spent early in his career, spent 3 years working directly for the chief of the U.S. tax court. And, one of the things you see at that level and from that perspective is a lot of the collection actions and collection due process hearing appeals that work their way up to that point in the system. And so, he's spent years and years, in the better part of a decade, in the aftermath of that, working through all sorts of collection issues, and he and I, enjoy litigating against the IRS and taking them on in a number of capacities. So I'm really, really glad to have him joining us today, just because of his unique expertise and insight. And then before we jump into the material, I want to point everybody to a resource that we have made available for free. Matt and I have spent a lot of time preparing this. It's an outline or compendium that provides a complete summary. It's a comprehensive summary of all of the coronavirus relief legislation and administrative developments. And what we found is that as we give a webinar, as soon as you have, there's something new. And really the only way we've found to keep everybody updated is to give you a link to this and just, advise you, hey, I would check back every few days, because we're trying to keep putting out a continuously updated compendium. But again, want to encourage those who are interested to go ahead and feel free to click and download and keep a copy of that as you'd like. So today's topic, we're going to be talking about IRS collection and collection resolutions as well. As many of you know, the IRS has several main collection tools. Those include liens and specifically filing of notices of federal tax liens, which alert the world and anyone who cares to know that the IRS possesses a tax lien. And the other primary tool of the IRS is its levy authority, and we'll go into some of what the prerequisites are for the IRS to actually exercise its levy authority. Matt, there are a number of kind of tried and true defenses, to these in terms of IRS collection or resolution. And there are some interesting ones, I guess, that have kind of risen up as a result of some recent IRS policy developments, I guess.
Yes, Jason, that's absolutely right. And just to put this in perspective, as the audience is probably well aware, the enforcement tools that the IRS has that you mentioned just a minute ago, liens and levies, are pretty powerful administrative tools the IRS can use to basically push taxpayers to pay any outstanding tax debts that are due. And typically, Jason, what we do as tax professionals is try, our best to defend against these types of actions to resolve it in a way that's favorable to our client. And what we typically deal with as these defenses, or at least historically, have been offers and compromises, installment agreements, requests for releases of levies, collection due process hearings, or requests for CNC status, innocent spouse type claims. And then what's happened recently is the IRS has come out with their People First initiative, which has basically stayed a lot of deadlines and other obligations that taxpayers are required to comply with to July 15th. And as part of this initiative, the IRS has also stayed, in most cases, the filing of tax liens and new proposed levies. But they've also indicated or hinted that it might be the opportune time with the way things are currently going for taxpayers to kind of take advantage of these traditional defense resolutions, particularly as a result of, the economy kind of faltering. And we will get into that in a minute. And then at the end of the presentation, we'll also talk about, what are typically thought of as defenses for collection, but that can be used for purposes of reducing the tax liability, some of these new provisions that came out in the CARES Act. So again, the IRS collection tools are basically going to be, the liens and the levies. As we mentioned, currently as of March until July 15th, a lot of the collection actions are being stayed to kind of give taxpayers a breather and be able to focus on other more significant things that are going on across the United States. But it's important to note that a lot of the collection alternatives to liens and levies do actually look in large part on the taxpayer's current financial condition. And in light of this, tax professionals, Jason, you and me both have had a lot of this activity where taxpayers or clients are coming to us and saying, they're being severely affected, at least financially, by the government shutdowns and business closure orders. So, is what we're looking at as part of this presentation is whether there's going to be some type of opportunity to help these taxpayers out, even though collection has been stayed until July 15th, and we'll go into that in a minute. But even if we don't have taxpayers that want to do anything right now, it's also going to be important to kind of note that at least as of right now, the IRS is looking at starting collection action again as of July 15th. So again, a lot of our clients are going to have been severely affected financially by COVID-19, and it's going to be important for us to be able to advise our clients after that date and when collection action actually begins again on what their options are and what they can actually do.
Absolutely.
So the first collection tool that the IRS has is, of course, the federal tax lien. And actually, under the tax lien, there is kind of two different buckets that we need to look at. One is the tax lien that actually arises by operation of law, and this is under 6303, where a taxpayer has been provided a notice of assessed amount and demand for payment, and the taxpayer fails to pay the assessed amount. After that occurs by operation of law under the Internal Revenue Code, there is a tax lien on the taxpayer's property. Oftentimes, this tax lien is referred to as the silent lien or the secret lien, because at this stage, the IRS has not typically filed a notice of federal tax lien notifying third-party creditors or parties that there is, in fact, a tax lien against the taxpayer's property. So when we think of the tax lien and what property it attaches to, it's very broad. The code actually indicates that the tax lien attaches to all property and rights to property, whether real or personal, that belong to such person. That includes tangible and intangible property as well. When the tax lien, when the taxpayer fails to pay after the notice of demand has been made, the lien actually relates back and attaches to property that belong to the taxpayer as of the date of the assessment. And it also attaches to any subsequent property rights that the taxpayer may actually obtain after the tax lien. In addition, if there's property that's been substituted, in other words, the taxpayer sells property for cash, it also attaches to that after acquired property.
It's interesting, Matt. One of the things I know you and I deal with a lot, it won't be for every attendee on this webinar, but our community property issues and the scope of liens and the IRS's ability to get to those. And I'll kind of point out, rather than going into all the nuances of it right now, but be aware that there are certainly some complexities when it comes to community property implications. We practice out of Texas. It's a nationwide practice, but we get a lot of work in Texas. Texas is a community property state and can raise a host of issues in terms of the attachment of the tax lien when it comes to community and separate property.
That's a great point, Jason, and that's a perfect segue for the next slide as well, which goes into the tax lien. As we know, the scope of the taxpayer's property or property rights is actually going to be determined under state law, and that's where Jason, what you mentioned, where community property laws can come into play and the various aspects of tax law. But it's important to note that although state laws do determine the taxpayer's actual scope of property rights, it doesn't necessarily affect, the ability of the federal government to enforce the tax lien. So there are some state laws that provide creditor protections, one of them being a homestead, and federal courts have basically said, that those state laws don't interfere with the IRS's ability to actually attach to that property.
Hey, you guys mind if I jump in and we'll launch our first poll here?
Please do.
Sure.
Thank you.
Perfect. All right, everybody, we're going to launch our poll. All right, we'll give everybody about 30 more seconds or so.
Matthew, I always find, just looking at this slide that's up, one of those areas where I think people are always kind of surprised to learn is that the IRS's, scope, once there is a property right identified under state law, this middle bullet point that, state law exemptions or restrictions on creditors, don't, from that point, don't impact really the IRS. And the most, the example that, this is a terrible pun, I guess, that really drives that point home is, the most common example there is the homestead exemption. And, the Rogers case is sort of the key case holding that, that does not apply to the IRS. It literally, once there's a lien there and there's property that lien attached to, the IRS has the ability to foreclose on a home. Now, there are certain additional procedural steps that it has to go through in that context, but again, it really underscores the fact that that they are really a super creditor.
Thanks, Jason. We close that poll. Back to you guys.
Great, thank you, Nathan.
Perfect. And Jason, just continuing kind of discussing the federal tax lien and the IRS's ability to enforce it. The tax lien arises by operation of law, and you've got the so-called silent lien where creditors are not aware of the actual existence of the lien. So what the code provides is that provided that the IRS has not filed the notice of federal tax lien with the appropriate government authority, that certain creditors are going to be protected because they are not going to be aware of the lien. And these include subsequent purchasers, holders of security interests, judgment creditors, and holders of mechanics liens. And the primary purpose of the IRS filing this notice of federal tax lien to kind of get in front of these creditors, and it's typically going to be under the rule of first in time, first in right. So whoever has their priority interest filed with the government authority first is going to be the one who jumps to the head of the line with respect to the property rights. Oops. And for the notice of federal tax lien, the regs kind of go in a little bit more of where the lien is going to be required to be filed. For real property, the IRS is going to have to file the notice of federal tax lien in the office where it generally needs to be filed under state law, where the property subject to the lien is physically located. For personal property, they're going to have to, again, file in the appropriate state office in which the property is subject to a lien, and it's going to generally be the personal property, at least, is going to be deemed to be located in the state where the taxpayer resides at the time the lien notice is filed. So significantly, the IRS does not file notice of federal tax liens in all cases. Instead, their guidance directs the appropriate IRS person to make an independent decision regarding the notice of federal tax lien filing. And when making this decision, it's going to generally be looking at the taxpayer's compliance history, whether the taxpayer meets some type of filing exception, whether the government's interests are going to be adequately protected with or without the notice of federal tax lien filing, and whether it's going to in any way hamper collection efforts.
As a general rule, the IRS is going to file the notice of federal tax lien if the aggregate unpaid balance of the assessments is 10,000 or more, kind of in some ways a magic number. And if the taxpayer doesn't meet one of the filing exceptions for a streamlined or a guaranteed or an in-business trust fund installment agreement, which we're about to kind of walk through these installment agreements. These are provisions or tools that you want to have in your toolkit, especially where you've got taxpayers who may be adversely affected by the actual filing of that notice of federal tax lien, that again kind of puts the world on notice of the silent lien that already exists. So streamlined installment agreements, the IRS can approve a so-called streamlined installment agreement if a couple of criteria are met. The unpaid aggregate balance of the tax assessments, and we point out here that includes tax and penalties and interest, is 50,000 or less. So again, there's a magic number, 50,000 or less. And the minimum installment agreement payment is going to be determined by dividing the balance by 72. In effect, that's 6 years that it would need to be paid over. The taxpayer will have to have filed all of their tax returns prior to entering into the agreement. So that's kind of a prerequisite. That without having those tax returns on file, they will not qualify. And the payments need to resolve all of the balances due prior to the CSED, or the collection statute of limitations, which is generally a 10-year period. Guaranteed installment agreements. The IRS may approve a guaranteed installment agreement if the taxpayer owes income tax of 10,000 or less, and that's excluding penalties and interest, has not failed to file any income tax returns or pay tax reported on those returns during the prior 5 years, can't pay the tax immediately, agrees to full pay the tax within a 3-year period. Taxpayer is going to also have to agree to file and pay all of their tax returns during that term, and the taxpayer has not entered into an installment agreement during any of the prior 5 tax years. And we've got a cite here to the Internal Revenue Manual provision, which you'll want to have handy and will and be in a position to provide to the IRS personnel in some cases where they're not familiar with the terms.
And Jason, I just want to point out, as we're thinking through this on COVID-19, I mean, would you agree that these are probably some of the easier ways to kind of avoid the notice of federal tax lien? But I guess in most cases, particularly where the tax liability is going to be higher, we're going to have to kind of be more creative in our defenses.
Absolutely.
So the federal tax levy, again, is the second kind of tool that the IRS has in its collection tool chest. And generally, the levy can occur if a taxpayer neglects or refuses to pay an outstanding tax debt within 10 days of notice and demand. Again, it's going to be similar to the tax lien and what the scope of the property that the IRS can actually seize, and we'll go over that here in a minute. And as the audience is probably aware, the IRS generally effectuates these levies through serving a notice of levy on a third party who has control of the assets of the taxpayer in question. So again, this slide is just pointing out again the scope of what the levy can actually do with respect to the taxpayer's property. In addition, the IRS can seize property subject to a federal tax lien, which has been sold or otherwise transferred by the taxpayer from the transferee or subsequent transferees, subject to certain creditor protections that we discussed earlier under 6323. So generally, the IRS will issue a notice of levy to any person who is in possession of or obligated with respect to property or rights to property subject to levy. And these include typical assets of taxpayers such as receivables, bank accounts, evidence of debt, securities, and also salaries, wages, commissions, or other compensation. Now, with the levy, you've kind of got two buckets of different levies that you can have. One is referred to as a continuous levy, in which once the IRS has served the levy notice to the third party, the third party is obligated to continue paying over those assets until the debt's been satisfied. Or you can have where it's kind of a one and done type of levy notice, where it's whatever the third party holds at that moment, they're required to give up, but not anything in the future unless another notice of levy has been issued. And Jason just got, yeah, there we go. So the next slide is pointing out, and Jason, go to it says at the top, tax levies on wages, salaries, and commissions. I think it's a,
Sorry, there we go.
there we go. So again, going just into our discussion of continuous levies, one of the bigger ones is going to be if the IRS issues a levy to an employer or to someone who owes, like an independent contractor, certain payments. These types of levies are typically going to be continuous levies. Accordingly, the levy is going to have continuous effect from the time it's made until it's actually released under 6343. Another big levy that can occur, and I've had several clients that have had these, is where the IRS actually levies against their Social Security benefits. These, again, are continuous types of levies. Typically under the Federal Payment Levy Program, which is what the IRS usually uses to levy against these benefits, it's going to be up to about 15% of the Social Security benefits each month that are payable to the beneficiary. And the IRS has taken the position, and it's been upheld in certain courts, that there are also other continuous levies that can occur, and generally these are going to be unqualified fixed rights, whether by trust or contract, that are unqualified kind of contractual rights. And it's just important to kind of keep in the back of your mind that the IRS can assert continuous levies on other types of payments as well. So the next levy that we all have some familiarity with probably is going to be bank levies. Significantly, these are not continuous levies. What's going to happen is the IRS will issue a notice of levy to the bank. There will generally be a 21-day waiting period until the bank is required to hand over any funds that might be in the bank account. And the purpose of this 21-day holding period is really to provide taxpayers with some time to contact the IRS and either arrange payment in lieu of the levy, or to notify the IRS that they believe the amount's not correct or some other type of procedural error.
I'll tell you, Matt and I are currently litigating a fairly interesting case in which we've taken some steps during this 21-day period to prevent, through some provisions in the Internal Revenue Code, to prevent the IRS from actually effectuating the levy after having served it. And for example, this one case we are litigating deals with an innocent spouse claim. raised and filed during this 21-day period. And so, do be aware that, in some instances, there are some sort of narrow exceptions that may, legally prevent the IRS from actually effectuating the levy if quick action is taken. So Matt, sorry.
Go ahead. I was just going to tell the audience. So now, we've kind of gone over an overview of the different collection tools the IRS has. Now, the next kind of group of slides is going to transition into the defenses that you can use against these collection tools, and particularly in light of current instances with COVID-19 and its effect on our clients.
And Nathan, this is probably a good time as we're transitioning to go ahead and launch the second poll question.
Perfect. We're launching that now. Give everybody about a minute.
Yeah, Matt, this is an interesting area where we've seen the IRS, come out shortly after the COVID-19 crisis began, and in addition to sort of a wave of, notices, many of which were extending filing deadlines, most filing deadlines and many payment deadlines have been extended to July 15th. But as part of that, kind of entire flurry of publications, the IRS introduced a new policy or initiative that it's referring to as the People First initiative. And as part of this, the IRS has indicated that it will not be filing notices of federal tax liens until this magic July 15th date, and that new levies will generally not be issued until that date. I will tell you, we've seen, as a matter of practice, I think we saw, Matt and I certainly, that there was a gap period where I think some of this new initiative and policy views had not made its way all the way down to many of the revenue officers. And so for a while, and frankly, even still, I feel like we're in a position of needing to alert them to it and make them aware of it. I've also seen that certainly the levy issuance and tax lien issuance has not been a clear cut, stop across the board. We've definitely seen a slowdown in this, but it's clear that the IRS has kind of reserved the right to continue its collection activities with respect to some taxpayers, and I think that's particularly they've geared towards higher dollar taxpayer non-filer types that may fit into that those categories, but also importantly, the IRS, as part of its People First initiative, has indicated that existing installment agreements and even accepted OICs may postpone their payments until July 15th.
Jason, there's been some guidance as well, I think, that's come out on the IRS with respect to taxpayers that are in installment agreements that have direct debit payments being made, correct?
Correct. So the IRS has, after kind of giving a broad pronouncement, that these installment payments could be postponed, it came out subsequently and indicated, where you've got a direct deposit installment agreement, they are not actually stopping those payments, but they do indicate that taxpayers can approach their financial institutions and actually instruct them to stop those payments. They just need to be careful to turn the spigot back on after July 15th. So Matt, you want to talk a little bit about offers and compromises? I know this is.
Hey, Jason, looks like the screen is frozen. If you don't mind, I'm going to try and reset it real quick.
Okay.
And go ahead and try and reshare, make sure that's working.
Okay. Nathan, we working?
I don't see it yet.
Oh, well, let's see here. Okay. I apologize for the technical difficulties showing up on my screen, but it doesn't appear to be transmitting.
Try to reset it one more time. We can always, like I said, make me the presenter if need be.
Well, Nathan, looks to me like we may need to go through your screen.
No problem. What slide number were we on?
Slide 24, please.
All right, so let me swap that.
While we're going, we'll go ahead and jump into the content. We're going to shift gears to offers and compromises, which Matt, I know this is one of those areas where you and I have felt there are particular opportunities at this point in time, for taxpayers to pursue offers and compromises, just because of the way that these are calculated, the settlement amounts.
I'm not seeing a page number. If you wouldn't mind telling me where I need to go.
The top slide is at the top. It says offers and compromise.
There we go. Good.
Right there.
Perfect. Just tell me the next slide and we'll get to go.
Great.
Perfect. Thank you. So as Jason was mentioning, one of the better kind of defenses, if you can get it, is going to be an offer and compromise. The IRS has the authority to compromise certain tax debts under Section 7122. In addition, and this is probably going to be more significant after July 15th for taxpayers that are in, a kind of worsened economic condition. If you file a offer and compromise and it's pending, then the IRS is going to be prohibited from levying against the taxpayer during that period. And if it's rejected, the 30-day period thereafter, unless the taxpayer does an appeal of the rejected OIC, in which case it's going to be after the appeal is done. Nathan, next slide, please. So some of the grounds for offers and compromise, of course, are going to be doubt as to liability, which is where the taxpayer can test the amount due. But you've also got two other potential avenues to challenge making full payment of the tax debt, and that's going to be doubt as to collectability and to promote effective tax administration. If a taxpayer has been impacted financially as a result of the COVID-19 pandemic, either one of these avenues might be useful to be able to try to get out of paying the entire tax debt that's due. And we're going to go over some of that here in the next couple of slides. And Nathan, the next one, please. When offer and compromise doubt as to collectability exists under the regulations in any case where the taxpayer's assets and income are less than the full amount of the liability. In determining whether to accept the proposed offer by the taxpayer, the IRS is going to review the taxpayer's ability to pay, which in turn requires the IRS to permit taxpayers to retain sufficient funds to pay basic living expenses. So generally, what in tax parlance and in IRS parlance, I should say, this calculation is going to be referred to as the reasonable collection potential, or the RCP. And again, this is going to be where taxpayers have been affected, and their investments have lost monetary value, or their businesses, et cetera. This may be a potentially viable way to be able to work with the IRS to resolve the outstanding tax debts. Nathan, next slide, please. So as part of making an offer and compromise doubt as to collectability, taxpayers are generally going to be required to file either a 433A for an individual or 433B, and in rare or some cases, I guess I should say, the 433F. This provides essentially a snapshot of the taxpayer's current financial position. It's going to ask assets, liabilities, income, etc., to determine the taxpayer's ability to pay. Under IRS guidance, if the taxpayer's financial position has, quote, significantly changed since they submitted a 433 as part of an offer in compromise, the IRS is directed to request a new statement, or the statement can be updated through written or oral communications the taxpayer or taxpayer's representative might have with the IRS. So, this is something to keep in mind for those of us that have clients with pending offer and compromises that are being reviewed, and where taxpayers' financial situations have changed as a result of COVID-19. You would want to reach out to the IRS and update them that the information that's already been submitted has significantly changed, and they need to look at the new information. And Nathan, next slide. So for offer and compromise status collectability purposes, the assets are generally going to be valued at net realizable equity. Generally, most assets are going to be valued at quick sale value, which is going to be an estimate of the price a seller could get for the asset in a situation where financial pressures motivate the owner to sell in a short period of time, usually hypothesizing 90 calendar days or less. Obviously, the QSV is going to be less than fair market value. There is an interesting notation in the IRM that's providing guidance to those IRS personnel that are looking at these, that a higher or lower percentage may be applied for as opposed to the 80% fair market value, depending on the type of asset and significantly current market conditions. So they are being directed to look at whether COVID-19 has had significant effects to the valuation of the assets for purposes of determining RCP. Nathan, the next slide. So after looking at assets and liabilities, the IRS is also going to look at the taxpayer's future income, which for purposes of the IRM is defined as an estimate of the taxpayer's ability to pay based on analysis of gross income less necessary living expenses for a specified number of months into the future. And for those of us that have prepared OICs regularly, we're aware that what the IRS is generally basing this on is past income to kind of look to project what future income is going to be. So again, just like with asset values deteriorating due to COVID-19, you are going to have some taxpayers who are also going to have the past income is not necessarily going to dictate what their future income is going to be, and these arguments should also be raised as part of the OIC for those of us that have clients that have been affected by COVID-19. Just the slide also indicates the IRS rules on projecting income. It's going to depend largely on the payment schedule that the taxpayer is going to make. If it's 5 months or less with 5 or fewer payments, the future income amount is going to be projected for 12 months. If the taxpayer wants a longer payment schedule, then the future income amount is going to be extended to 24 months. And Nathan, next slide. So under the Internal Revenue Manual, as a general rule, the taxpayer's current income should be used in the analysis of future ability to pay. This is going to include circumstances in which the taxpayer's income has been recently reduced based on a change in occupation or employment status. In many cases, the IRS is looking at past financial information the taxpayer submits and is going to average the income from those years to try to ascertain the future income projections. However, the IRM does provide specific guidance for those taxpayers who are either long-term unemployed or temporarily or recently unemployed, which is going to impact a lot of our clients. For long-term unemployed, the IRM instructs the IRS not to use income average. And there's actually a tax court case out there in a CDP context where the tax court judge found it was an abuse of discretion for the settlement officer in that case to use income averaging in these circumstances. So for long-term unemployed taxpayers, the IRS is directed to use the taxpayer's current income in the future income calculation, unless there is another or there's evidence that seems to suggest the taxpayer is going to secure employment in the future. On the other hand, if the taxpayer is classified as temporarily or recently unemployed, the IRM instructs the IRS to use the level of income expected if the taxpayer was fully employed and if the potential for future employment is apparent. Nathan, next slide. So the IRM also recognizes that in some cases it's going to be difficult or impossible to properly calculate the taxpayer's anticipated future income. In these instances, the IRM directs that the IRS may actually use the taxpayer's current income, but also secure a future income collateral agreement. The IRM directs IRS personnel to do this, where it's reasonably expected that the taxpayer will be receiving a substantial increase in income in the future. And I actually had a conversation with someone at the IRS that was a higher level manager that deals with offers and compromise. And our discussion, this was a month ago, was that they were really looking at the potential to use these future income collateral agreements, but that they didn't want to if they didn't have to, because there's monitoring that's involved, but that they were expecting to issue some guidance on this in light of the COVID-19 pandemic. So that will probably be forthcoming. Nathan, next slide. So future income collateral agreements, if the IRS is going to use them, these are typically going to be found on forms 2261 for individuals and 2261A for a corporation. The taxpayer is going to agree to pay a certain percentage of their annual income in the future when the income exceeds a specified amount. Significantly, this can also include items that we don't typically think of as income for federal income tax purposes, such as if the taxpayer receives a gift, bequest, or inheritance. Typically, the agreement is going to be entered into for a 5-year future compliance period, so looking forward 5 years. And our use, if the IRS is going to use these types of agreements, is it's important to keep in mind that the percentages and amounts involved in the collateral agreement are going to be negotiable and based on the taxpayer's financial situation. Nathan, next slide.
I'm going to jump in. I think we're going to launch poll number 3. And that is up, and then we'll leave this up for about a minute, and then we'll go to the next slide. Perfect.
Thanks, Nathan. And while we're waiting on this, I'll just talk a little bit about with the reasonable collection potential. So we've gone over the assets, how they're going to be valued, the income, the potential for collateral agreements that the IRS may use, particularly for taxpayers who are unemployed, and it's going to be difficult to figure out what their future income is. After all that's determined, the taxpayer is allowed to also assert that they're entitled to allowable expenses, which are going to consist primarily of the taxpayer's necessary living expenses under the IRM. For these purposes, the IRS usually uses national and local standards to determine the allowable expenses, unless the amount would result in the taxpayer not having adequate means to provide for basic living expenses in the first place. So there is some room, particularly with respect to expenses that are not going to typically occur, that are occurring now for businesses and taxpayers. You can assert those types of expenses as well and trying to get the RCP down.
All right, thanks so much. We're going to close this poll. And next slide.
And Nathan, go one more. So again, the key in the offer and compromise context is going to be this reasonable collection potential. As the tax court has noted in their opinion in Alston v. Commissioner, which came out a couple years ago, it's a key concept in tax law and fairly easy to understand. You're looking at assets, liabilities, and income, but it's an exhaustive kind of approach that the IRS uses, and there's a lot of back and forth in trying to determine the taxpayer's reasonable collection potential, which can be a relatively complicated process, particularly for clients that we have that have a lot of things going on with businesses, et cetera. Nathan, next slide. So in determining whether to submit an offer in compromise doubt as to collectability, tax professionals should, of course, review the facts and circumstances that are going to be unique to each client. Bearing in mind the IRS is going to look at the financial position of the taxpayer as of the date of the OIC or shortly thereafter, and the information that's submitted at that time. So with COVID-19, we'll probably have a lot of taxpayers where the business entity valuations, for example, to have an interest in a partnership or an S corp, have decreased. You're going to have taxpayers who are no longer employed or have significant decreases in earnings, investments that have been impacted, or additional medical expenses or other allowable expenses that the IRS historically may not have allowed but may allow now. And again, it's important to keep in mind, that in light of what's going on now may be the time to visit with clients that have these outstanding tax debts to see whether the timing is right to make an offer in compromise doubt its collectability. Nathan, next slide. So again, the IRS and RCP is going to look at various assets, and I've got these on the slide. Y'all can take a look at these when y'all have time, but this is what the guidance and the 433s are going to request. Nathan, next slide. So another offer in compromise that's separate from the doubt as to collectability is the effective tax administration, OIC. Generally, this is kind of a last resort. It can't be, the first one that has to be used is the doubt as to liability. If your clients are certain that the amount due is correct, then you go to the doubt as to collectability. And then if that doesn't work, the IRS will consider whether compromising the tax debt will promote effective tax administration. Generally, under this scenario, the IRS will accept an OIC ETA if the IRS determines that although collection in full could be achieved, in other words, RCP is higher than the offer, collection of the full tax liability is going to cause the taxpayer economic hardship. So, and importantly, in addition, even without economic hardship, the IRS may accept the OIC ETA where compelling public policy or other equitable considerations are raised by the taxpayer warranting relief. And Jason, as tax professionals, when you kind of read this loose language, I think it kind of screams out that, with the COVID-19 pandemic going on, that that we would typically think of our clients going through these economic hardships, and that I can envision some scenarios or fact patterns where public policy or other equitable considerations in light of COVID-19 do warrant taxpayer relief.
Absolutely, couldn't agree more, Matt. And it's one of those instances where there are a lot of bits and pieces of evidence that can be used to create a compelling offer and compromise submission. So when you look to the policy statements and the statements that congressional leaders and the Treasury Secretary and others are making, they're kind of presenting the very fact that some of these considerations exist, and I think that's part of where we see an opportunity, sort of an unprecedented opportunity, historically speaking, is that these areas, particularly in the offer and compromise route, they present a real opportunity to get rid of or settle tax liabilities. And I think the key is really to put together very persuasive, packages that tell a story and really demonstrate the sort of intangibles and these characteristics that may qualify a taxpayer under these ETA criteria.
Great points, Nathan. Let's move to the next slide. So this I've actually used in the past, and a lot of tax professionals don't know about this guidance. If you have a tax court petition that's been filed, which keep in mind you're in a deficiency posture, you're still trying to figure out what the amount due should be. The IRM actually permits taxpayers in certain instances to offer an offer in compromise while the tax court case is pending. One of the downsides is, depending on the process, is that you have to usually get a stipulation of the full amount of the deficiencies and penalties that are found in the notice of deficiency. But I have actually used this technique successfully to get a good result for one of my clients, and it's just with all these trial dates that have been pushed off into the future for the tax court proceedings. Just bear this in mind for any of your clients that may be in a position to kind of resolve the case through an offer and compromise as opposed to litigating it in the first place. Nathan, next slide.
One moment, I think we're going to launch our fourth poll, and then we'll go right back to it. And that is up. We'll give everybody about 30 more seconds or so. Just get those votes in.
Perfect. Thank you, Nathan.
Matt, with our quickly running out remaining time, it may be a good idea for us to kind of go back and just kind of revisit the high points of the People First initiative. Make sure everyone's kind of aware of those, those timely, I guess, changes for their clients. And, again, want to underscore what we've been talking about is now is just, it's one of those times that historically values are low, and there are, projected income for many is significantly less than it was months ago. And so, we just see an avenue of offers and compromises. And as Matt pointed out earlier in the program, the IRS has almost invited them through some of its guidance and public statements. So it will be an interesting, period that we're entering into on the IRS resolution front.
That's absolutely right, Jason, and that's another good segue into the next slide, Nathan. I know tax professionals, particularly in the last month, have just been buried in all the guidance that the IRS has come out on. And again, one of their things they came out with in late March was the People First initiative, and it has some significant changes for those that have are going to be submitting offers and compromises. One of them is if you've got a pending OIC application, the IRS is permitting you additional time to provide any requested additional information they've asked, substantiation, bank accounts, etc. The IRS has also agreed they're not going to close any pending OIC requests before July 15, 2020 without taxpayers' consent. For payments, we mentioned this earlier, that payments due between March 25th and July 15th, taxpayers have the option to suspend those payments until after the 15th of July. Delinquent return filings, the IRS has agreed not to default OICs for taxpayers who are not in filing compliance for 18. However, they're instructed to go ahead and file or get it ready to file by the July 15th deadline. And then for new OIC applications, the IRS again has urged taxpayers with outstanding tax debts to come forward and submit OIC applications to kind of provide a fresh start for those that probably desperately need it. Nathan, the next slide. So after OIC has been submitted, and if a taxpayer is lucky enough to have it accepted by the IRS, There are some procedures the IRS is required to follow. Generally, there's going to be some type of write-up that's going to support acceptance of the OIC that's going to be submitted for managerial approval. If the OIC involves a tax liability of $50,000 or more, including the interest and any other additional amounts or penalties, it's generally going to have to be reviewed by IRS counsel to determine whether it meets the standards necessary to grant one, and whether it also conforms to the IRS's policy and procedures. If the OIC involves a tax liability of less than $50,000, then it doesn't necessarily require IRS counsel review. Nathan, the next slide. I know we've only got a limited amount of time at the moment, but I just want to briefly go into installment agreements and some of the other defenses that unfortunately it looks like we're not going to be able to get into it as part of this presentation. But again, installment agreements are going to be similar, at least for purposes of determining the installment agreement payment as an OIC is. The IRS is going to review the 433 and look at assets, liabilities, future income, et cetera, to make a determination of what the taxpayer can pay on the installment agreement. So it's going to be important to keep in mind everything we've discussed previously with respect to, bringing down that potential payment on the installment agreement. Nathan, next slide. So under the IRM, again, installment agreements are required to reflect the taxpayer's ability to pay. If the IRS determines that the financial condition of a taxpayer with an existing installment agreement has significantly changed, the IRS may alter, modify, or terminate the agreement. So for those that have clients out there with existing installment agreements, you might consider, particularly if they're having difficulty in making those payments or will have difficulty after July 15th, and requesting from the IRS a different payment plan. Nathan, next slide. So one other potential defense that you can have, particularly with respect to a levy, is a request to release it. This is found in section 6343. And it only applies in certain instances, which generally involve, again, this keyword of economic hardship, looking at the financial condition of the taxpayer. They're going to be looking at what the taxpayer's reasonable living expenses are going to be in light of, their income or assets, and particularly with respect to what the levy is, or proposed levy or current levy is going to seize. In determining the reasonable amount of basic living expenses, there are a number of factors the IRS looks at. One I just want to point everyone's attention to is number 5, which is any extraordinary circumstances such as a natural disaster, which certainly I think, Jason, would include COVID-19.
Agreed.
Nathan, next slide. So to request a release of the levy, the taxpayer can either do it orally over the phone or in writing. Generally, if you're going to make this type of request, keep in mind the IRS is probably going to ask for certain information, which is found in the regulations, and it's going to include the name, address, TIN of the taxpayer, the description of the property levied, the type of tax and period for which the tax is due, as well as the date of the levy, the originating IRS office, and significantly a reason for why the levy should be released. Nathan, next slide. So the IRS has come out with guidance recently, and this is on their website on the COVID-19 developments. One of the questions is, will levies and wage garnishments remain in place, or will these be paused from April 1st to July 15th? And can the taxpayer request a pause? If so, how? And the IRS has come out and said they're not automatically releasing levies. Taxpayers are going to have to come forward with a request to release it, which is going to be looked at on a case-by-case basis to determine whether the levy is having an economic hardship on the taxpayer. Again, economic hardship is going to be looking at the reasonable living expenses of the taxpayer, as well as whether they're going to be able to meet their basic needs. To request a release of the levy, particularly with a lot of the IRS offices closed, the IRS has given a fax number that you can send a request to, and it's found here on this slide. Nathan, next
I
slide.
just wanted to jump in. We're about 5 minutes over now, but it's okay to keep going. But it's just kind of, Jason and Matthew, do you have an idea how much time we have left on the presentation?
Well, I think we're about to wind it down. We wanted to make sure we got at least to the release of levy information for.
Okay. Well, I just want to let our audience know, if you need to leave, you've met your CPE requirements. We will be recording this session and sending that link a little later today. We're still recording, so if you need to drop off, it's okay, but please feel free to stay on as well. So Jason and Matthew, go ahead and please continue.
And I also, Nathan, want to point out to everybody, we've got, we've created the slides that have the materials on them and the resources and citations. So for those who, want, and there's just a couple of additional topics to try and round it out, but that material is in the slides.
Perfect. Jason, I'll also just mention to the audience as well, just again, the compendium that we have on our website. As you can see, there's been a ton of guidance by the IRS on these issues, as well as Jason and I have spoken a lot on the PPP program as part of the CARES Act and some of the tax relief provisions in the CARES Act. And all that can be found in the compendium, for the audience to kind of take a look at their leisure. And Nathan, next slide, and then we'll wrap it up. So again, just finishing up on the request for release of levy. Again, the significant part of this is going to be whether you can show there's an economic hardship. For these purposes, the request for release of levy only applies to individuals. The tax court has actually come out with an opinion that says business taxpayers can't seek relief under economic hardship grounds, which interestingly enough, the case was vacated on other grounds, but it's still a good opinion as to whether a request for release can be made to anyone other than an individual. And with that, Jason, I'm done. If you want to add anything else.
No, I just want to thank everybody for sticking with us today. And I want to point out one thing in particular, that we've got some materials towards the end of the slides dealing with a few of the tax-specific amendments within the CARES Act, which provides some additional sort of unorthodox, I guess, collection alternative approaches or resolution approaches that may be worth considering, where your taxpayer has access to funds in a retirement, in a qualified retirement fund or plan, or may have other tax assets such as net operating losses and previously restricted excess business losses. Obviously, there are a host of things in this area. We, as always, make ourselves available to you. So if you've got questions about some of this, or you've got additional topics, that you'd like to discuss, feel free to reach out to Matt or I. We really, again, appreciate everyone, and again, want to commend the compendium to you, as it hopefully will be for many of you a helpful resource in the days ahead. So with that, we thank everybody for tuning in. Hope you all stay safe out there, and we look forward to seeing you on the next one.
Jason, thank you so much. Really appreciate you being here. We're getting a lot of great feedback. Matthew, thank you as well. Reposting this right now. Thank you. Thank you for the session. Great presentation. Great job with your webinar. Thanks again, guys. Appreciate it.
Yeah, thank you all.
Thank you.
To our audience, thank you so much for attending. Like I mentioned, we did record the session. We'll send you that link a little later today. We'll try and get your CE process a little later today as well. You should see that in your account by tomorrow. Thanks so much, everyone. Hope to see you all. Future webinars.